First of all, thanks so much, everybody, for joining us. It's great to have you with us, and we're excited to launch what is now a bit of a new format for our education series. I'm Amy Achmoody. I'm an associate advisor here at Flagstone Financial Management, and I'm joined by my friend and lead wealth advisor, Dan Staus. As I mentioned, we started a new format with our education series, and we have decided to dig deeper into specific financial planning topics per quarter. So we're supplementing that with blog articles that go into more detail about the topics, and then summarizing at the end of the quarter with our office hours webinar. So instead of the monthly webinar that we were doing, we are now doing it quarterly, and we're looking forward to that, to providing more education for everybody in more detail. So today we're summarizing this quarter's topic, which was things to consider in the death of a spouse. You can also access the blog articles that both Dan and I wrote on our website, www.flagstonefm.com. And we'll take any and all financially related questions toward the end of our webinar, and you can type those into the Q&A box. It doesn't have to be associated with this topic. You can ask anything that you want. I assume we'll have some tax questions in there, so go ahead and feel free to ask. And then finally, Flagstone Financial Management is a registered investment advisor. Information presented is for educational purposes only and does not intend to make or offer this solicitation for the sale or purchase of any specific securities, investments, or investment strategies. Investments involve risk and, unless otherwise stated, are not guaranteed. Be sure to consult with a qualified financial advisor or tax professional before implementing any strategy discussed within. Past performance is not indicative of future performance. And with that, Dan, let's get started.
Yeah, thanks for that intro. And I'll just echo what Amy said about asking questions. I mean, the primary purpose of these quarterly office hours is really to take more questions from folks who may not want to wait for a annual meeting with us, or who don't feel comfortable emailing us, and they just want to kind of interact with us more often than our scheduled stuff. But this can kind of be a way to answer questions so that other people can hear those questions and answers too, because a lot of clients have similar questions. But then, like Amy said, we're also covering the quarterly topic. So this quarter's topic is the death of a spouse. I mean, the really unfortunate reality for a lot of clients is that they come to us because they're dealing with issues related to the death of a spouse, or they have to deal with that at some point in the life of our relationship together. So we hope that folks find this information helpful or beneficial. I mean, there's a lot of issues that people go through when they're dealing with the death of a spouse. A lot of them are softer, non-financial questions, and a lot of them are more technical, money-related questions, and those are the ones that we're going to be discussing today. We're going to kind of give a higher-level overview of those things today. Know that our blog articles go into a little more depth on each of these. So again, like Amy said, visit our website, just check out the blog articles. But if you've already read them and you're attending today and you have questions about what you read, right now is a great time to ask clarification questions on those things. So I'm actually going to walk through a checklist that we have that compiles all of these different things that we're talking about into one place. So I'm going to share my screen with you, and we're just going to walk through this checklist together. So first, we have these cash flow issues on the top left-hand side of this checklist. So the first one, will your cash flow needs change? So likely the answer to that is yes. I mean, there's only one spouse now who's consuming things, and so you're going to have a new budget because of those new expenses. Your income might change as well, because if you have pension benefits, those might change. If there was Social Security, that income might change. So forming a new budget or a new spending plan might be in order. The second one is related to Social Security benefits. Sometimes when a spouse passes away, your Social Security benefits will change. Sometimes they won't. That really depends on a lot of variables, and it's really complex. And even we as advisors have to refresh our memory on those rules whenever we're dealing with it. So I'd really encourage you to just reach out to us if you're a client and you have questions on this, because it is so complex. Did your spouse have an IRA when they passed away? And if so, were they starting required minimum distributions already? When you hit age 72, you have to start taking money out of traditional IRAs. So it's important to know that if they did reach that age, they do still have to satisfy their RMD for that year that they passed away. The financial institution that's holding that account should be able to help you with that. In addition, another issue you're going to have to deal with if you were listed as the beneficiary on that IRA, you'll have the choice of making that IRA your own IRA or leaving it as what's called a beneficiary IRA or an inherited IRA. It's a small but important difference there. And a tax professional or financial planner can help you determine what makes most sense there. If your spouse was receiving a pension, that's something that you'll need to understand how that's changing or how that's going to change. When your spouse initially elected to get that pension, they probably made a choice on how it would be handled when they die. So, for example, they might have had the option of saying, okay, I just want to receive this pension, this income stream for my own life, and when I die, it's completely gone, and my spouse doesn't get anything else, and I'm going to get $1,000 a month in that example. Alternatively, they might have had the option of saying, well, when I die, I want my spouse to continue receiving it, but they're only going to get if they elected that, they're only going to get $900 a month instead of $1,000 a month, and then maybe only 50% of that goes to the spouse when they pass away. So there's a lot. I mean, those are just two scenarios or examples, but the reality is there's a lot of claiming options. They were likely already made. I mean, sometimes that pension will go to the surviving spouse, sometimes it won't. So if you're someone who has a pension and it hasn't started yet, we can help you make the decision of, well, should I just do this for my own life? Should I have it go to my spouse as well? Should it be 50%, 75%? A lot of options there that we can help with. The next topic here beyond cash flow is estate settlement issues. And this is the one that tends to get more attention and tends to be more administratively complex. So first up, did your spouse appoint you as executor under their will? Well, what does that mean? It's basically just whoever's in charge of settling stuff when the will or when someone passes away. If you're in this position, you might feel overwhelmed. You might not feel confident in your ability to do this, but you can contact an attorney to assist you. There's going to be a lot of questions on the list that we're talking about right now today that you really need the help of an estate planning attorney to help you with. You also might need the help of a tax professional and a financial planner. So I understand if you don't feel confident or like you're going to be able to do this on your own, but the reality is you don't have to do it on your own. You can have a team of professionals helping you. But the first person to contact is an estate planning attorney to help you get the ball rolling on settling things. If your spouse passed away without a will, you're going to have to deal with the rules that your state has for those types of situations. And that can kind of be a pain, but again, an attorney can help you. If your spouse is still alive and you don't have a will or your spouse doesn't have a will, I would highly encourage you to get in touch with an attorney so that you can get a will created. You can avoid a lot of time and headache by doing that. And it's not crazy expensive compared to the value that it provides. Do you have more assets than you need to maintain your lifestyle? So let's say, for example, just easy example, let's say you have $1 million to your own name, your spouse has $1 million to their name, and so they die and they give you their $1 million. Well, maybe you only need like $1.5 million total to accomplish your financial goals. So there's an extra $500,000 there that you don't really need. Well, it might be to your advantage to disclaim that $500,000. In other words, you're saying, hey, I don't need that $500,000. So instead of me receiving that as a beneficiary, I'm going to let that pass on to whoever was next in line. So there can be tax reasons or financial goal reasons why you might want to do that. Those advantages can be pretty sizable in some scenarios. So I'd encourage you to talk to, again, an attorney, financial planner, and a tax professional about whether you should do that if you have more than you need. You'll also likely need to change titling on different accounts or property or assets. And so those things are going to likely be retitled. Like if you have a joint investment account, for example, then that financial institution that holds that account will likely reach out to you to get that changed into your name. But it's also a good opportunity for you to consider, well, should it just be in my name? Should I add someone or a charity as a beneficiary? Like, how do I need to handle that? That should be considered when you redo your own documents, which is later on, I mean, it's further down on this list, but I'll mention it now. Now's a good time to update your own estate planning documents. So as you do that, you'll need to make decisions on how to retitle the assets that you might inherit. If you and your spouse's combined estate value is more than 24.12 million, so up on the list, I'm on this kind of top right section now. If it's more than 24.12 million, you might have to pay some estate tax, and you'll work with a tax professional on how to figure all that stuff out. But the next thing on this list is if there is a tax liability, a federal state tax liability, there might be some ways to reduce that. For example, you can use what's called an alternative valuation date. So if, let's say your spouse passes away, your combined estate was $25 million on the day that they died. And that's over those limits, as you can see. By the way, those limits are going down, or going to be reduced significantly under current law in a few years. So this amount might seem super high now. It's going to be later, or it's going to be lower later though. But let's say your spouse dies, your combined estate's worth $25 million. But then 6 months later, maybe markets have done really poorly, the stock market's down, and 6 months later that estate value is only $20 million. And that's actually below the exemption limit. Well, the IRS allows you to use that valuation date of 6 months later to reduce that amount of state tax owed. And in that example, it'd eliminate the estate tax owed. So next up on the list, are there assets not yet identified? So there's a couple of odd, maybe less common things that you might consider or think about. This first one is points on credit cards. So for most people, the amount of points that they have probably isn't worth the hassle of like trying to figure out whether you can get those transferred. But if someone like me dies, who's a travel points enthusiast, who has hundreds of thousands of travel points that have like thousands of dollars worth of value, then it might be worth reaching out to the credit card companies or the hotels or the airlines to figure out, hey, can we transfer this to the spouse or not? Safe deposit boxes are another thing. With safe deposit boxes, if your spouse was the only owner on that box and they pass away, it's kind of a pain in the rear to get access to it. You need to follow probate rules on getting access to it. So again, work with the attorney and the bank. If your spouse has not passed away, I would encourage you to have not just yourself and your spouse, but also a trusted family member on that agreement, on the safe deposit box agreement. Because if you both pass away, you want someone else to be able to easily get in there. So common examples would be children. If you have an adult child who is willing to be on there and who you trust, it's a good idea. I meant well, I guess really quick, state agency and unclaimed property sites, like that's a real thing. People can find unclaimed property on there. It's kind of crazy. I had a family member who actually found some unclaimed assets on the state of Nebraska's unclaimed property site. It was worth like $25, but it was still there. So check that. Are there digital assets that should be preserved? So cryptocurrencies, media like photos and videos, NFTs, those are all assets that you might want to preserve because either number one, they're worth a lot, or number two, maybe there's just a lot of sentimental value to those things. So if your spouse hasn't passed away, talk to each other about how to form a plan of how to get that stuff. That can be kind of complex. Insurance issues. So was your spouse employed at the time of death? Maybe there's some group life insurance there where you'll get some insurance proceeds. If your spouse is a veteran, there might be some veteran benefits there. If the death was related to work or an accident, there might be additional death benefits, either through workers' comp or some life insurance policies are what's called accidental death and dismemberment policies, where there are additional life insurance benefits if they were related to an accident. Did you or your spouse have a minor child that's disabled? If so, there could be some Social Security benefits. And then lastly, like, are there life insurance policies that you may not know about? You might need to do some detective work to figure that out. There are some good ways to prevent your spouse from not knowing about a life insurance policy that you had. You can, I mean, at a minimum, have a conversation about what exists. But then there are also ways to have like a digital binder or a physical binder that's kind of like an end of life instructions sheet that tells your spouse what to do if maybe you were the person who was the more financially minded person or the more organized person. We actually have a digital personal financial website that can kind of act like that. So if you're a client and you want to learn more about that, let us know. I'm flying through topics right now. Amy, I wonder, do we have any questions on anything I've talked about thus far, or should I just keep pounding through them?
Well, one that relates a little bit to the estate planning part, Dan, and the question is, let's see, if I have a living trust, do I still need a will?
Yeah, I mean, a will is kind of a bare minimum. So yeah, I mean, ultimately you should talk to an estate planning attorney, but yeah, having a will is going to be like a thing that we suggest for everybody. I mean, even people who are single, that's kind of unrelated to the topic of this, but yeah, even people who are single and young who feel like, I don't know if I really need one. I mean, it's not going to be very expensive. So yeah, I think it's a good idea for everybody.
We have some other questions, but I do want to say first, and you touched on this a little bit, Dan, but the time in the death of a spouse is a very vulnerable time for people, and you're dealing with grief, you're dealing with the logistics, you're dealing with family members. There's a lot that expands, in all different directions. And so we really encourage people to lean on their professionals in their field. So whether that's the estate planning attorney or the tax professional or the financial planner, all of those people have the expertise to deal with these issues. And that's part of what they do. So it's important to have those relationships and lean on those professionals in that time. So we encourage that. I'm going to ask a couple other questions, Dan, that start to get outside of the realm of this topic. So do you have anything additional that you want to add to this, or?
Yeah, we'll finish up these topics and then see if that spurs anything else, but then also address those other ones that you mentioned. So,
okay.
Speaking of leaning on professionals, though, this next topic is tax issues, and so we really do encourage people to enlist the help of a tax professional for these. Excuse me, and that's not just like be sure to mention that disclaimer, but then you don't really need to. No, like seriously, you need to enlist the help of a professional for these tax issues. So first up is related to capital gains on a house. So it's worth mentioning that, like when a married couple is together and still living, if you buy a house for like $300,000 and you sell it for $800,000, then as long as you meet a couple conditions, you don't have to pay tax on that $500,000 worth of gain that happened. Typically, you have to pay capital gains tax on things that you buy and then you sell later at a higher price. But there's an exclusion for a home, and that exclusion is up to $500,000 for a married couple. Well, it's only $250,000 for a single person. So what happens if your spouse dies? Do you then do you only get to exclude $250,000 because now you're single, whereas when you were married you could exclude $500,000? Well, the short answer is no. You still get to exclude $500,000, but it's only if the house is sold within 2 years of your spouse's death and you meet those other conditions that you would have had to otherwise if they were alive. So if you are in a situation where you want to downsize or move, then you still get to exclude up to $500,000 if you meet the other conditions. If you own property jointly with your deceased spouse, whether that's a house or a joint investment account, it depends on what state you live in as to how it's going to be treated, but there's going to be a potential step up in tax basis. In Nebraska, if you own an account jointly, then you get a step up in basis of 50% of that account. So there could be ways to actually get 100% step up that require some planning ahead of time. So if your spouse already passed away, that window of opportunity is gone. But I won't get any more detail with that. If you have questions, let us know, and we'll follow up afterwards. But yeah, there could be some planning opportunities there. The bottom line is that a step up in basis is a good thing that reduces tax. And so, yeah, there's some benefits there. Let's see. Do you need to confirm that your spouse's prior income taxes have been paid? So if you're working with an accountant, they'll know like if you need to do any follow-up there to find out, hey, did my spouse have income that they haven't paid tax on yet? You just need to make sure that it is paid. In the year that your spouse passes away, you can still file jointly. And then in the following 2 years, if you have dependent children, you can file as a qualifying widow or widower. Let's see, I'll do a couple other rapid fire things here. If your spouse had stock options, grants, or restricted stock, you'll want to talk to a tax professional and that employer about how that's going to be handled. Does this event change how much you have in your stocks versus bonds within your investment accounts? Lots of reasons why it might. So talk with a financial advisor about whether that has changed. If your spouse is a business owner, you'll want to talk to an attorney about the succession plan there. Hopefully one was in place already, but if it wasn't, you'll want to talk to an attorney and form a plan about how that needs to be sold. There might be annuities or other illiquid assets that you'll need to figure out what are my options there. So you can talk with the financial institution and with your financial planner about what your options are there. And I'll kind of leave it at that. The last two I'm just going to kind of skip over, but that was a ton of information in a really short period of time. So I'd love to hear questions. I'd also encourage you, again, check out the website for the more details on the blog article. And also, if you want us to email you a PDF of this, let us know. If you're attending live right now, just let us know in the chat if you want a PDF of this, and we'll email you. If you're watching a recording, you can just email us at info@flagstonefm.com, and we will reply to you with a PDF of this. So yeah, time for some questions.
Yeah, we have some questions, and thanks so much, Dan. That's really good information.
Yeah.
So one question that we have is, I moved from Colorado to Arizona. My current will was drafted in Colorado. Should I update now in Arizona?
Yeah, when you move to a different state, it's always a good time to have talk with an attorney about whether you should update your documents, because yeah, there might be reasons why you would want to update them. Sometimes trust laws are different. Sometimes property ownership laws are different. I believe Colorado is a community property state. And I think Arizona might actually be as well, but I'm not 100% sure from memory. But particularly if you're moving from a state that's a community property state to one that's not, or vice versa, visiting with an attorney is definitely in order. But yeah, still good. Moving states at all, even if it's from one state to another that has property titling laws, you should have an attorney look at your documents and recommend whether you need to update them. So, I mean, they might just look at your documents and say, no, you're fine, but they might bill you for 30 minutes of looking at your documents. Or they might find issues why you should update them, and then they would engage you with the whole project. So, yeah, great question.
All right. We have some investment and tax questions. I retired last year and started receiving Social Security payments. Do I have to pay taxes on my Social Security benefits?
Yes, potentially. So the rule is that up to 85% of Social Security benefits are taxed as income. There's a detailed calculation to figure out exactly how much of them are going to be taxed as income. I will be honest, most of the clients we work with do have to pay tax on 85% of their Social Security income. If they're, well into retirement and they're getting required minimum distributions and such, or there's pension income, they're probably going to be paying tax on 85% of that. Yeah, there's a small portion that you don't have to pay tax on, or if your income's low enough, then you might be able to avoid paying tax on a lot of it.
Thanks. And how does the rise in interest rates affect bonds? Are they still a good investment?
Yeah, that's a good question too. Rise in interest rates is big in the headlines right now. Yeah, I mean, directly how it affects things is as interest rates go up, bond prices go down. So the immediate effect is that bond actually loses value. You still get the same amount of interest or coupon payments that you were getting before. But yeah, there is kind of this immediate effect where the bond loses value. If you're buying new bonds, then those new bonds will have higher interest rates on them, so that's a good thing. But yeah, whether bonds are a good investment is a completely unique thing depending on the person. So, bottom line, if you're a client, talk to us, because we'll be able to look at the whole picture and decide if bonds are appropriate for you. But in a lot of situations, they are appropriate.
All right. Well, those are the questions we have. Dan, do you have anything that you want to wrap up with?
I don't think so. I mean, I think I would just conclude by echoing again what you said earlier about leaning into your professionals who you're working with, because it's a lot to go through when you lose a spouse. And so we help people with this all the time. And so we'd be happy to help you if you're going through this. Or if you haven't gone through this and you're just wondering about how could I prepare for my spouse passing away, we'd be happy to help you think through that as well. And then maybe the last thing is that if, I mentioned earlier that if you're going to be the executor of an estate, you can enlist the help of an estate plan attorney. If you just still feel like it would be too overwhelming to be in that role and to have like hardly any involvement of it, you can always appoint a corporate fiduciary to be the executor of an estate, or at least as a backup. So if you have documents right now and your spouse hasn't passed away yet, we often recommend listing a corporate fiduciary in a backup role, so that if you pass away and you listed your spouse as executor, but they're just feeling overwhelmed, they can take a step back and say, look, I just don't want to do this anymore. It's too much. And then they have some sort of like trust company come in and take over. And a lot of times the trust companies will charge like a flat fee to be the executor of their estate. If there's a trust, then the corporate fiduciary might, that's happening ongoing, then there might be some sort of percentage fee. But yeah, you can talk with your estate planning attorney about doing that as an option too.
All right. Well, good information, and thanks so much. And thank you for joining us. We're really glad to have you all here. If you have questions, like Dan said, please reach out to us. Our next quarter's topic will be coming out soon, so be on the lookout for that. And we'll hope that you join us at our next quarter office hours. Talk to you soon. Bye-bye.
Thanks, everyone.